Hi, and welcome back. Nancy Beauvair here with Agape and NEXsteps. This week, I wanted to bring your focus and attention on something called incapacity planning. Now, I know that you've heard me say in other videos how important it is that you have your affairs in order by having a will, an enduring power of attorney, a medical directive. Those actually are the key components of your incapacity plan. But a lot of people aren't familiar with that term. So this week, I wanted to bring our focus and our attention directly to the issue of incapacity. A lot of times when we're thinking about planning for the future, we think about death. We think about what happens when we die, and we have those documents in place. But very few people that I've come across plan for incapacity. And that's not all that uncommon. No, dementia cases are expected to increase 65% in Canada by 2030. That will impact nearly 1 million more people. If those approximately 1 million people haven't done any of this planning, that's going to leave their families in considerable turmoil while they try to figure out and navigate those rough waters. Now, I don't know anybody who gets up in the morning and says, today is a good day for me to have a stroke or for me to get into an accident, end up in a coma. But those are the kind of life events that happen every day. So when you're planning for the future, this isn't something that just people 65 or older need to plan for. Anybody can have one of these life events trigger something that creates turmoil and chaos and financial difficulty among their loved ones. What happens if you don't have any of these documents in place? Well, if you end up in a coma or incapacitated, or let's say that you are struggling with dementia, but you think that you have a lot of time, but it advances a lot quicker than you thought. You're being in denial about the progression and the eventual need for these documents doesn't undo the damage that happens when you don't have them in place. If you don't have these in place, first of all, nobody is going to be able to make sure that your medical wishes are adhered to. If you don't have a medical directive and you haven't named somebody, there's going to be decisions made at the medical level, the doctor's level. They may have conversations with your family members, but they won't ensure that your wishes are being followed unless it's in a legal document. What happens if you haven't created that enduring power of attorney? Now, the difference between a power of attorney and an enduring power of attorney is that a power of attorney often gives certain powers over a certain specified event. So, for instance, if you were traveling to Europe and you were going to be gone for 6 months, you might do a power of attorney and name somebody back in your home country to have the authority to pay your mortgage, pay your bills, keep everything current. An enduring power of attorney is something that gives the authorized person, the attorney, the authority to act even if you become incapacitated. So if you have that document in place and something does happen, then the attorney can act on your behalf according to the powers that are laid out in that document. Some people worry about creating that enduring power of attorney because they're concerned that their named person might take advantage and get access to their documents and their finances and potentially abuse that power. And while there is that risk, that can be mitigated. You can actually have it triggered based on your incapacity or various other triggers. You can set that up with your lawyer when you're going to do these documents. The other thing is that you need to really measure and be sure about the person who you are naming in these documents, that they do have your best interests at heart, that you do trust that they are going to act as you would act if you had your full capacity to be able to do that. Now, the final thing is about a will. A will cannot be created and it cannot be updated or adjusted if you don't have capacity. So if you have created your will and there's been a life event that has happened, but you are either suddenly in a coma, unable to act on your own behalf, or perhaps your dementia has advanced to the point that you are no longer legally or mentally competent to make any adjustments to that will, then the changes can't happen. Or if you haven't even created a will, you cannot create a will. And if you don't have a will, then you're going to die intestate, and your family, your loved ones are going to have to go to court and petition to be able to become the executor, the administrators of your estate and of your accounts. That is time consuming, it's costly, it's frustrating, and I'm sure that you don't want to put your loved ones in that position. So now let's assume that you have created these documents. Where do you store them? I know that we've all been told that we should have a safety deposit box at a financial institution to store our valuable assets and our documents. The problem with that is that if your will is in your safety deposit box, your executor may have extreme difficulty accessing those documents because the financial institution will require the original will in order to act on that. So what you want to do instead is make sure that you have the original kept somewhere safe. If you have a safe at home or leave it with your lawyer, make sure that it is somewhere safe and that your executor knows where these documents are. Make sure as well that the people you've named on these documents have a notarized, true, certified copy of all of these documents so that they can keep them in a safe place. I know that there's quite a bit of movement these days to digitize everything and keep a digital version of all these documents, but you still need the original will in order to apply for grant of probate, in order to move forward on these things. That is not a good idea, especially for your will. I hope that this video has motivated you to take care of this planning. It's so critical now, more than ever. And that's regardless of age. If you don't know where to start, if you already have documents, but you're not sure how to update them and what to allow for, give me a call. I'm a certified executor advisor. I can have a consultation with you, can review your documents and make suggestions and make sure that you are meeting and dealing with the appropriate legal or financial to make sure that your estate is cared for and that your best interests are taken care of going forward, not just for if you become incapacitated or upon your death, but also to ensure that your plan is consistent with your current lifestyle. Thanks very much for joining me. I look forward to talking to you again next week. Bye for now.